We've got some breaking news here, gang. The Supreme Court just gave the Trump administration another huge win on immigration. It's all part of a pattern of wins that the legacy media doesn't want to talk about. We got the latest on the ruling, and we've got yet another occasion for Justice Autopen to show the world just how radical and unqualified she really is. Hey gang, it's me, Dr. Steve, your patron professor, enjoying yet another glorious day in the Trumpian golden age that you made possible back in November of 2024. So if you want a front row seat on how you continue to change the world in ways you never even imagined, make sure to smack that bell and subscribe button. So here's the breaking news. The Supreme Court just ruled that border agents do indeed have the legal authority to deny re-entry to green card holders. So those are legal permanent residents who have been charged with crimes. Now, that's the key. That's what was at issue. The issue was simply charged with a crime, not convicted, not sentenced, charged. The Trump administration argued that under existing immigration law, Customs and Border Protection officers have discretionary authority to turn back lawful permanent residents at the border when those individuals are facing serious criminal accusations. And the Supreme Court agreed. Now, I want you to understand what that means in practice here. A green card is not a passport. A green card is not citizenship. A green card is a privilege of legal residency extended by the United States government. And that government, through its elected executive, retains the authority to make judgments about who re-enters this country when there is reason for concern. You see, the left has spent years arguing that once someone has got a green card, well, that's it. They are untouchable. They can pass through that border whenever they want. The Supreme Court just said, no, that's not true. That's not the law. And the Trump administration was right. But here's what I really want to focus on, because the ruling doesn't exist in isolation. This is the latest. This is a part of a long list in the sustained, accelerating string of Supreme Court victories for President Trump, particularly when it comes to immigration and border security. So earlier this term, the court ruled that the Trump administration could deploy what's called the Alien Enemies Act. That's a law dating back all the way to 1798. They could deploy that act to deport members of the Tren de Aragua gang, the Venezuelan criminal organization that had been spreading its operations across American cities. The lower courts, if you could believe it, they tried to block that. The Supreme Court stepped in and said, no, the executive branch most certainly does have this authority, and it certainly may use it. And it goes all the way back to the 18th century. And then there was the birthright citizenship. So we have yet to get the full ruling on that. But President Trump, of course, signed an executive order challenging the longstanding interpretation, the wrong interpretation, in my view, of the 14th Amendment that grants automatic citizenship to anyone born on American soil, including, astonishingly, the children of illegal aliens. Lower court judges, including several Biden appointees, immediately issued nationwide injunctions blocking that executive order. The Supreme Court, while allowing the underlying legal challenge to continue, significantly curtailed the scope of those injunctions, so preventing individual district court judges from issuing rulings that block a presidential order everywhere in the country simultaneously. So that's a structural shift in how federal courts can resist the executive branch, and it's absolutely enormous. And then there's the ICE enforcement. So federal judges had tried to declare schools, churches, other what they called sensitive locations off limits for immigration enforcement, effectively creating sanctuary zones. Supreme Court overturned all those restrictions, affirming that the executive branch, not a single district judge in a blue state courthouse, that the executive branch sets immigration enforcement policy, period. So, of course, LA Mayor Karen Bass was furious. Gavin Newsom was furious. Supreme Court didn't care, right? Facts don't care about your feelings. So what you're watching is the Supreme Court systematically dismantling the legal architecture that activist judges in the lower courts have spent years constructing to frustrate federal enforcement of our immigration laws. The left's strategy was simple and cynical. Shop for a sympathetic judge, get a sweeping nationwide injunction, and tie the administration in legal knots while the border remained open. The Supreme Court has now closed that playbook chapter by chapter, case by case. And let's be clear about what this means politically. The Democrats and their media allies spent years telling you that Trump's immigration agenda was unconstitutional, un-American, would never survive legal scrutiny. They were wrong. They were flat out wrong on alien enemies. They were wrong on birthright citizenship injunctions. They were wrong on ICE enforcement locations, wrong on green card deportations. The Constitution, properly read, gives the executive branch broad authority over the border. And this court is affirming that one ruling at a time. Well, at least most of them are. There is, unfortunately, one particular justice that continues to demonstrate that she is way out of her league here. And in this latest round of rulings this week, she didn't disappoint. We've got the latest absurdity from Justice Autopen. You are not going to believe this. Gang, you have all got to go right now to turleytalkscrypto.com. I'll tell you why in a moment. What I'm about to share with you is the single most blatant Wall Street about face of our lifetimes. In 2017, BlackRock CEO Larry Fink called Bitcoin, I kid you not, quote, an index of money laundering. Bitcoin was money laundering. Today, BlackRock holds over 800,000 Bitcoin. We're $63 billion. That's more than the United States Treasury has, more than any nation on earth has. So here's the question every patriot needs to ask. The same Wall Street establishment that called Bitcoin a scam for 10 years, that mocked you for asking about it, is now its single largest buyer. Are you watching what they said, or are you looking at what they're doing? Gang, this is the great financial reversal of our lifetime. President Trump put Bitcoin in America's strategic reserve. BlackRock is buying it by the billion. The Bitcoin Act in Congress authorizes $1 million more for the Treasury. The only people not in the room, the everyday Americans, told it was too risky for their retirement. Well, that's what I want you to know about Block Trust IRA. They built the platform that lets you do inside your retirement account exactly what BlackRock and the U.S. Treasury are doing on their balance sheets. Institutional cold storage custody through SFOX and AI portfolio management through their amazing Animus AI system. I've been a client of Block Trust IRA for months now, and gang, I can tell you I love them. Right now, for Turley Talks listeners only, go to turleytalkscrypto.com, get up to $2,500 in free crypto when you fund a qualifying account, plus a complimentary 30-minute call with their team where you get real answers and real solutions. Wall Street laughed at Bitcoin for a decade. Now they're buying it by the billions. Don't be the last one in. It's time to take control of your financial destiny. Go to turleytalkscrypto.com. Justice Autopen strikes again. You may have heard about the Supreme Court's recent ruling. It was actually a unanimous ruling, 9-0. Every single justice, including Autopen, in the case of the United States versus Hamani. So Ali Hamani was a recreational marijuana user who was prosecuted under a federal law that bans gun ownership for anyone who is a, quote, unlawful user of a controlled substance. So the charge carried up to 15 years in federal prison and permanent loss of his Second Amendment rights. Justice Neil Gorsuch, writing for the entire court, struck that down. He found the law inconsistent with the Second Amendment, noting that Hamani was not a drug addict. He had not used his firearms in any threatening manner, and that the historical analogies that the government had used, like colonial era laws disarming habitual drunkenness. It simply didn't apply. So 9-0, everyone agreed, case closed, right? Good day for the Second Amendment, right? Wrong. Justice Ketanji Brown Jackson could not leave it there. She agreed with the rest of the justices, but she used her concurring opinion to launch a sweeping attack on the Bruen decision. That's the landmark 2022 Supreme Court decision that requires all gun regulations to be grounded in the historical tradition of the founding era. Even though she agreed with the decision rooted in the Bruen precedent, she called the Bruen framework, quote, unworkable. She complained that it imposes on judges, quote, I'm not kidding you, the unfamiliar and difficult tasks of sifting through centuries-old evidence in order to answer contested historical questions. And she called on the court to scrap the entire framework in a future case and replace it with something that liberals call means-end scrutiny, which is a technical legal term for let judges decide for themselves what gun restrictions seem reasonable today. I kid you not. Let a liberal judge figure it out. And whatever that liberal judge wants, they could slap it on there. Easy. Now, my namesake, the constitutional law scholar Jonathan Turley, he immediately called this out for what it is. And his observation cuts right to the heart of it. Justice Jackson is complaining that judges should not be burdened with studying history and original meaning when it applies to the Second Amendment. You can study history all you want when it comes to like racism, slavery, bigotry, blah, blah, blah. But when it comes to the Second Amendment, no. Justices should not be burdened with studying history, especially when it comes to issues surrounding the Second Amendment. The work is just too hard. The evidence is just too old. The questions are just too contested. Now, unfortunately for AutoPen, that burden, the burden of actually seeking to understand what the Constitution meant when it was written and ratified, is not a bug in in constitutional interpretation. It is the entire point of constitutional interpretation. It is precisely what prevents 9 unelected judges from simply rewriting the law to reflect their own personal policy preferences. And as Turley notes, to suggest that Jackson's preferred means-end scrutiny approach would be less inconsistent and arbitrary is only true if you control the court with justices who already share your political conclusions, which is, of course, exactly what the Democrats are promising to do if they retake power. Pack the court with 4 new justices in the image of Justice Jackson and never lose another case again. That's not a paranoid fantasy. Democrat strategist James Carville said out loud earlier this year, if we get power, we're adding states and we're packing the courts. And the attitude in the room, he said, was basically, F it, just do it. So that's the stakes. And Jackson's not some outlier being unfairly criticized by conservatives. Since her confirmation in 2022, she has compiled what Jonathan Turley calls one of the most radical judicial records in the court's history. Her solo dissents, which are many, the opinions where it is literally just her disagreeing with every other justice, including her fellow liberals, they've drawn sharp criticism from both conservative and liberal colleagues. In fact, her fellow liberal justices have publicly called her claims baseless and utterly irresponsible. The old saying is this: if 3 liberal justices dissent to a decision, then you could make a reasonable argument on their behalf. If only 2 liberal justices dissent, that would be Sotomayor and AutoPen, well, then the dissent is more or less likely silly. But if only 1 dissents, the usual one, then it's outright batshit crazy. But here's where Turley lands in all this. And again, I think he's exactly right. What Justice AutoPen is proposing, what the Democrat left is promising to instill in a packed court, it's not merely a different legal philosophy. It's actually the end of constitutionalism as a constraint on power. It's the replacement of fixed law with the living, breathing preferences of whoever sits on the bench. Preferences that, by remarkable coincidence, always seem to reach the same progressive Marxist conclusions, protecting the same progressive constituencies and expanding the power of the same progressive administrative state. The Trump administration keeps winning at the Supreme Court precisely because the Constitution keeps winning. A law grounded in text, history, and the original understanding of the American founding is, as it turns out, a remarkably durable thing, even after decades of activist erosion. The border is being enforced. The Second Amendment is being upheld. And on the other side, Justice Autopen is writing concurrences that even her own liberal colleagues find ridiculous. It's our job to make sure that Justice Autopen's constitutionally illiterate opinions remain completely and permanently alone.